This is Zebra Family Channel. Good morning and good afternoon and good evening wherever you are around the world. Have you subscribed in our channel? If not, what are you waiting for? Please like, share and subscribe.
See, the intimidation versus incrimination that I put you from the meeting and the introduction in reference to section 204 in the transcript. Do you agree with me? Yes. 36. She says, sure enough, when I stuck to my guns would only answer questions related to my Zonda Commission testimony, they gave up and indicated that I left them no choice but to treat you as a suspect. And you'll confirm that's when the warning statement was taken. That's a statement taken of a suspect. Then she regarded that as effectively a charge sheet. She said in 37. And then she says in 38, my legal representatives have informed me that not only is this not legally permissible, as an investigator must reasonably believe that there are grounds to arrest and or to charge someone. If in fact was being a recalcitrant or uncooperative witness, as they've suggested in the court of law, and it was open for them under the Criminal Procedure Act to either serve me with a subpoena, section 180, have me subpoenaed by the court, section 186, or any of the remedies for a recalcitrant witness under 189.1. So she's saying, due to the fact that she wasn't prepared to give the answers that were requested of her, she was charged, is what she's saying there. And she should have rather have been charged as a recalcitrant witness. Do you have any comment?
No, I don't. It's procedure. No, I don't.
39, she says, the decision to intimidate, threaten and promptly charge without reasonable grounds to is the most blatantly egregious contravention of my constitutional and other rights, both as a witness and as a citizen of South Africa. Do you have any comment to that?
Well, at that stage she hasn't been charged yet.
She was informed as per the warning statement she's a suspect.
She's a suspect. The final decision lies with the prosecutor.
Once the prosecutors have regard to the warning statement and the contents of the docket, you agree with me?
Absolutely.
40. They effectively detain me within the halls of the South African Embassy and institutional building is supposed to be there for the protection of the rights of South Africans. Do you have any comment?
That's not true.
And she says in 41, nothing about any of this conduct and behavior has been ethical. Worse, that they then lie in the court of law informed that I was not cooperating with officials and was therefore charged. So she says that you misled the court and you said that she hadn't been cooperative. Do you have any comments?
No, I didn't.
And she says in 42 that the legal representatives have informed her that is certainly not any ground in law to unlawfully arrest someone with corruption, money laundering and fraud. Ordinarily that would be the case. If somebody is not prepared to give you the answers, you don't lay those charges at the door. You can charge them with perjury if they've lied, etc. Do you agree?
I agree.
And then she expresses a desire that this be shown to various officials. Now, where this becomes important in relation to the reason why I asked to cross-examine you is I want to take you back to correspondence predating the arrest of Mr. Mahashule that then impacts on this jurisdictional question, and I'll try to cut through it as quickly to get directly to the point. In order to do so, I'm going to omit the first letters, but they are available, but if you want to refer back, you're more than welcome to. I have copies for you. You'll see it's in correspondence from October 2020. But the important, as far as I'm concerned, starting point would be a letter, and I've made copies for His Lordship, yourself and the state, dated 25 October 2020. Just persist. This letter is sent prior to the arrest and bail application of Mr. Mahashule. Do you understand? It's a letter from my instructing attorney, Mr. Victor Nkwashu, from Victor Nkwashu Attorneys Inc. on 25 October 2020 with the heading, and it's addressed to the DPCR, to General Labia, and to the prosecuting authorities. And it refers to, and it's important that I'll show you this, our clients, Mr. Ace Mahashule and Ms. Malawi CHOLOTA, it's accused 13 and 16 respectively. And it says, and that's why I told you, if you want the earlier letters, I'll make them available to you, but I didn't want to go beyond the jurisdictional issue with Ms. CHOLOTA. Paragraph 1, your letter dated 22 October 2020. Now, previous letters dated 7 October 2020 and 17 October 2020 refer. At the outset, we record that your letter ex facie only responds to our letter of 7 October, not our letter of 17 October. 3. While we appreciate your response as regards our client, Mr. Mahashule, we respectfully request you to urgently respond to our letter of 17 October 20 as regards our other client, Ms. CHOLOTA. So I especially left out those earlier letters because I don't want to go beyond the realm of what I am to tell you it related to the leaked information that Mr. Mahashule was going to be arrested and requesting confirmation of it. But we're not going to deal with that in this ring-fenced trial that we're going to do with Ms. CHOLOTA. And here you'll see. It says, as conveyed to, and this is paragraph 4. As conveyed to in our 17 October 2020 letter regarding Ms. CHOLOTA, we'd appreciate that our client is a citizen of the Republic studying in a foreign country. Now that's correct as far as you know. At that time she was a student studying in America, you agree?
I agree.
Right. And it's clear from this letter that Ms. CHOLOTA is a client of this firm of attorneys, do you agree? It's in the heading and it refers to as our client. 5. In consequence, therefore, our client is particularly apprehensive to be visited by law enforcement authorities of that country, purportedly or ostensibly on your instructions or request. So what had happened, and just as you confirmed it, by virtue of the MLA, Mutual Legal Assistance, Ms. CHOLOTA had been visited by the FBI in America, as at October 2020 already. You confirm that, and you're aware of it.
Oh, yes.
Thank you. 6. In the premises, we strongly urge you to confirm whether this is in fact true, and if not, on what basis the FBI, Federal Bureau of Investigations, will contact our client in respect of matters being investigated in South Africa, currently being investigated by your office. You confirmed that you were aware that the FBI had been to see Ms. CHOLOTA at the request of the South African investigative and prosecutorial authorities.
Can I just mention one thing? I cannot recall that they actually interviewed her. I know we asked them to confirm the address, but I cannot confirm whether they interviewed her during that period.
Well, it's important that you tell us that you are aware that in October 2020 there was a request through MLA, Mutual Legal Assistance, to the FBI to confirm Ms. CHOLOTA's address, and it was confirmed.
Yes.
Paragraph 7. Respectfully, the inference is inescapable that the visit by the FBI was at your request and or at the request of someone under your authority. It is inconceivable that a foreign law enforcement agency would be investigating a domestic matter falling within the remit of your office. So it's clear. Well, all they're saying is the visit by the FBI, and you say to verify the address, was at the request of the South African authorities, and you confirm that. Notwithstanding the protections our client, Ms. CHOLOTA, is entitled to in terms of the law of the United States of America, despite your status as a foreign national, we remind you that you and the officer's obligations in terms of the Constitution have extraterritorial application to the extent that the life and or liberty of our client may be at stake. So there's the saying that she's protected by law in terms of the Constitution, even though she's in America. 9. In consequence of the aforesaid, request you to urgently reply to our letter dated 17 October 2020 as regards Ms. CHOLOTA. So there's a request asking whether there was this investigation, whether the visit had happened at the request of the South African authorities that had remained unanswered, and they're asking for an answer. You see that?
Yes.
10. Regarding other claims in Mahashule, we note that your letter gives our client little comfort. It may respectfully be described as total avoidance of engagement. Then it's about Mr. Mahashule in paragraph 11, but in 12 they say, as a public functionary exercising potentially invasive powers as regards our client, you're held to the highest standards of legality, including taking responsibility for what clearly appears to be an orchestrated trial by media currently being conducted against our client. So the allegation there, and I'll show it to you, is that they were contending that your office and the DPC and the MPA had leaked these visits to the media. Do you have any comment?
No such thing according to me.
And I've handed a letter that I was just given in court now. It's an email from Mr. Donation on the 18th of November 2020. I'll make the copies. Where it's under tab PQ, I beg your pardon. And yes, this is the email that was referred to. And he refers in the penultimate, in the fifth paragraph to this visit, and he says to Ms. CHOLOTA, pertaining to your safety, this has been read out in court before, pertaining to your safety, you're of the view that you're not in any danger. The assistance of the FBI was requested for the plain and simple reason to locate you and inquire from you whether you will cooperate with the SA police and prosecution. This they did, and I was pleased to note that you had, and I believe still has, a positive attitude and that you will cooperate with us, which we appreciate. The involvement of the FBI must therefore in no way be seen as negative towards you or your safety, but rather the contrary. So you agree that you were aware of this, it's here in the emails, and they didn't verify her address. They also inquired over whether she would cooperate with the South African authorities. You agree?
I do.
And it's clear that Mr. Donation was aware of it and that what's recorded here is accurate.
Yes.
So now we've established as a fact that there was this MLA and the FBI went to verify address and said, are you going to help? No further arrangements were made with her as far as anybody else was aware, even as per her own statement to agree. Back to the letter, where I explained to you about the media, the trial by media, and then in 13, Mr. Nkwashi says, in the premises, we request your urgent assurances that, sub 1, neither you nor anyone in your office is communicating with members of the media regarding the potential arrest of our clients. And sub 2, neither you nor your office will engage in such conduct described above, given a serious violation of dignity that there should be.
Yes, and then the letter from
Mr. Nkwashi, on 25 October 2020 will be 13.11.
Yes, it is this one. I don't know if you can see that from.
No, that will be 13.2 more.
Okay. So where is 13.1?
13.1 was the first letter I wrote. I handed you this today.
Is there no way that we can perhaps get all these documents that now deal with the trial, witness trial, under some tab in this Exhibit 9, in the big bundle, perhaps under PQ?
my lord, we can look at that. I'm not sure with regards to these emails, as we had already had the Constitutional Court order that was submitted by counsel for Ms. CHOLOTA being X1. So I don't know, perhaps if we can then follow suit and all the rest then being X2, X3.
Yes, I think let us keep it then as it is now. Just to avoid any further confusion. But I'm with you. Thank you, Mr. Otis.
So if we look at this letter, it's a letter in response to what we now have as 13. It's a letter from the RD, Investigating Director of Corruption, addressed to Mr. Mahashule, where they speak of it's a response to the letter of 7 October 2020, and they explain what the purpose of the RD is, paragraph 2. In the third paragraph, they say, regarding information received that a warrant for the rest of the client was issued, we can only state that as a matter of course, we do not disclose information regarding the identity of suspects in ongoing investigations. Once an accused person has been brought before court, their identity and the charge or charges thus will become a matter of public record. In this context, we believe it prudent to refrain from responding to rumor speculation. Our focus remains accountability, and that includes doing our work scrupulously. You will no doubt advise your client of these options should you believe his rights have been violated. So they don't take issue with anything that's stated in Mr. Mahashule's letter pertaining to the FBI and what they have done to review it.
Just give me a moment, Mr. Otis, please.
Thank you. I need to find my papers.
This letter that you dealt with at length of Kwashu attorneys, that is the one where certain allegations are made. Just to sum it up, in respect of Ms. CHOLOTA and the conduct of the FBI and so forth, that letter is this one, if you can see that far. That is one we should now mark
13-1.
13.
True, that's what's causing the confusion. I would have put it in place to it.
Yes, now it is already marked 13-1. I do have it, so you can have this one, you can take it back, because I have two of them. So I have this 13-1, and then you are referring, I also have a 13-2, and you have referred to this letter addressed to Mr. Kwashu, your letter dated 7 October 2020. Refers. Is that the last one that you dealt with? That is 13-2. Fine, thank you.
Now, the next letter that I want to show you, I need to contextualize it, is 23rd of November 2020. So it was after the Mahashule's bail application. It had previously been referred to in the previous matter as ESM 11, but I've made copies for my learned friends and for his lordship and yourself, so they used to need to do. So that should be 13-3. see that this is highly relevant to what we do here now. So it's a letter from Mr. Mahashule on 23 November 2020. That's 10 days after the bail application. Addressed to the Director of Public Prosecutions, Advocate Somaru, and the NPA, Victoria, Advocate Sunila Victoria. It says, Henry State versus Elias Sekobela Mahashule, Bloemfontein Magistrate Court. 1. As you're aware, we represent Mr. Elias Sekobela Mahashule, our client. This letter is addressed to you on his instructions. 2. Our client and we have cited an article in the City Press that our erstwhile client, Ms. Malawi CHOLOTA, when your advocate, Jade the Nation, had informed the court and us as a state witness, they claimed to be unaware that she had become a state witness. Now we know that that's accurate from the emails that we have in the PQ. You know that. 3. The article further refers to quotes that are alleged to be contained in an exchange of emails emanating into alia from Ms. Malawi CHOLOTA. 4. It is a matter of record that we represented Ms. Malawi CHOLOTA when she was required to appear before the judicial inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state. That's what I told you previously. Mr. Nkwashu had acted for at the State Capture Commission. And you are aware of it. Yes. 5. Additionally, as required in terms of the rules of that commission, we compiled an affidavit on Ms. Malawi CHOLOTA's behalf. We duly took an oath and signed the affidavit before a commission of oaths on 5 December 2019. That's the affidavit that's in Exhibit 9 that was signed by her before the commission that you have in the docket as well. Do you agree with that? 6. In that affidavit, Ms. Malawi CHOLOTA expressly recorded under oath that despite Mr. Dukwana's assertion to the contrary, she had not been involved in liaison in relation to what he had referred to as the asbestos eradication audit. That's consistent with what she told you. She had no direct knowledge of what had happened in relation to the asbestos audit, the subject matter of this trial, not trial in the trial, do you agree? 7. In the circumstance, it was clear that Ms. Malawi CHOLOTA had consulted with our client and us and provided us with a version of the issues that subsequently became part of the subject matter of the draft charge sheet in the envisaged criminal prosecution of our client. Consequently, there can be no doubt that she was a defense witness. Do you agree with it?
Well, I've seen it here.
Well, let's break it down, Captain. She sat with her attorney, Mr. Nkwashu, at the request of the State Capture Commission investigators, compiled the statement with his assistance that was exculpatory of both herself and Mr. Mahashule, and deposed to it under the guidance and as a client of Mr. Nkwashu. Do you agree?
Yes, I agree.
And that, in effect, would make her a defense witness. In other words, the person says, these are the allegations, this is my version, I and this man haven't done anything wrong, that's my statement. She's a defense witness, you agree with me?
I would say she's a witness. I can't say defense witness in the statement. She's a witness in the allegations.
So let's break that down because it's rather important. To be a state witness, she'd have to attribute criminal conduct to somebody. Do you agree with me?
Yes, I do.
She didn't in that statement. Do you agree with me?
Yes.
That makes her a defense witness. I'll go, before I even jump to a conclusion, let's break it down further. If she gave a statement that exculpatory of Mr. Mahashule, she's his witness saying he did nothing wrong. Do you agree?
Yes, I agree.
That's what that statement did. Do you agree?
I agree.
That made her a defense witness. 8. Despite the above detailed events during October 2020, we were informed that Ms. Malawi CHOLOTA had been visited by the Federal Bureau of Investigations in the United States of America, where she was studying at the request of your officers. We then addressed a letter to you on 17 October 2020. The letters that we've referred to, where you acknowledged that the FBI was sent to her address.
Yes.
9. The issues raised in that letter were not responded to in any meaningful manner. This resulted in us addressing a further letter to you on 24 October 2020. To date, that letter has not been responded to in any meaningful manner. He's complaining that he hasn't received adequate responses. You agree?
Yes.
10. Instead, we were notified that a warrant had been issued for the rest of our client. We then assured you that our client would cooperate in his matter of record that he has done so. That's Mr. Mahashule, and you were the investigating officer. You can confirm the cooperation and that everything was done by agreement in the bail application, other than the quantum of the bail.
Yes, I do.
11. At our client's bail application on 13 November 2020, we were informed for the first time in open court that Ms. Malawi CHOLOTA was a state witness. In fact, it was a condition on our client's release on bail that he was not entitled to communicate with her. You can confirm you were there and saw that, is that correct?
Yes.
In fact, for all intents and purposes, it was as a result of a consultation between yourself and Mr. Donation that was made a bail condition. Do you agree?
Yes.
At that stage, the only statement that you had from her was the statement that we have here, that we referred to, and you've now conceded, was as a defense witness. Do you agree?
Yes.
12. Our client and we have not communicated with Ms. Malawi CHOLOTA, but we are astounded by the manner in which she went from being a defense witness to becoming a state witness. In this regard, we respectfully refer you to the Supreme Court of Appeal judgment in S versus M, 2002, Volume 2, South African Criminal Law Report, page 511, the decision of the Supreme Court of Appeal, at paragraphs 28 and 29, the subsequent cases that applied that dictum. So I referred to in open court when I was applying to cross-examine you. You agree?
Yes.
13. We further respectfully request you to provide us with clarity in regard to what is stated in the newspaper article, and in particular to confirm the veracity of the alleged email exchange between Ms. Malawi CHOLOTA, the DPCI, and Advocate Donation, and provide us copies thereof. That's the PQ, and now we have the Exhibit 12 that you didn't know about before, emails. Do you agree with that?
Yes, I do.
Right. Mr. Nkwashu and our team, including Mr. Mahashule, were not copied in on those emails for obvious reasons. You agree? And that's why this is accurate. Somehow it got to the press, as you'll see. 14. We find it reprehensible that you were not forthright with us at that time when, in fact, you knew that she was represented by our office and was clearly identifiable as a defense witness. You see, the complaint there is that it's reprehensible, knowing she's a defense witness. You don't talk to her attorney, you go directly to her and tell her she's a state witness, which we believe is improper. And you question it.
Well, I don't have an opinion.
15. By virtue of Advocate Donation having informed the court that the matter is trial ready, save for the rest of two outstanding suspects, we request you to provide us with a copy of the A, B, and C sections of the police docket to enable our client and us to prepare for trial in this matter. You know that was subsequently provided, but B and C was after a threatened court case that was involved. Just to confirm it. 16. Our client and we find it unconscionable that the media has access to information relating to this case prior to the contents of the docket being disclosed to the defense. You'd agree that's wrong, that the media can publish the contents of your docket before it's even disclosed to the defense.
No, it's not correct.
Thank you. 17. In the premises, we respectfully request that you urgently make available to us a copy of the entire contents of the docket as well as the indictment, so that we can ensure that our client's constitutional and pre-trial rights are respected. That's normal to give an indictment to the docket. 18. All of our clients' rights, including but not limited to the right to argue at the trial in this matter, that a stratagem was adopted to intimidate Ms. Malawi CHOLOTA with the object of procuring a retraction of a previous affidavit or expressly reserved. You see that? The very issue that this court is dealing with, you agree with me?
Yes.
Here it is summarized as far back as 23 November 2020. Do you agree with me? 19. We formally record that our client will comply with his bail conditions and not communicate with Ms. Malawi CHOLOTA, but it is a tried principle of our common law and has been recognized by the Supreme Court of Appeal that the freedom of witnesses from interference, whatever side they may take, is a keystone in the temple of justice. It's a quote from the decision of State versus M that I read before this honourable court. You agree with me? 20. We eagerly await an acknowledgement of receipt of this letter and a meaningful response to issues raised herein. And then you'll see, so that the City Press article that's referred to is attached, and it refers, and if you want, we can go through it with pleasure, but I'm quite certain that you have full knowledge of this article. Do you agree with me?
It's a while back, but yes,
Well, we can just look at the headings if you like, because that will summarize it quickly for you. You'll see that it's headed Ace Mahashule Saga State Witness Bombshell. And it says that the case of fraud, corruption, money laundering against ANC Secretary General Ace Mahashule could be heading for rocky ground as his former personal assistant, a key witness, has turned against the prosecuting authorities and has denied agreeing to testify for the state. Do you agree with that? And you'll see that they refer to the correspondence between the Hawks, Malawi CHOLOTA, which he says we were surprised to learn through the media after Mahashule's first court appearance just over a week ago that she had turned state witness against her former boss. You've seen those memos.
I've seen it.
And there's a quote there.
Just a moment, Mr. Harris. Captain, you are now here referred to many things that appear in this in this newspaper article. I'm just wondering, can you keep up, or do you want to read this letter at your own leisure?
Well,
Not letter, the article.
the article, I'm aware of this, my lord. As I said, it was a while back, it's 2020. I can't recall all the exact facts, but I'm aware of the fact of the things that appeared in the media. That was said, and I know it was a huge issue during that period. But to go into detail exactly what was said, that I cannot recall, that I have to read.
Because I'm only asking you because I want to give you the opportunity to read through this article if you want to. If you say to me, no, it's not necessary, counsel can go on asking you questions about the article, then it's also okay with me.
I appreciate my word. I would, if I may, it depends on what Advocate Harris will refer to in the article, if I may say that. Then I can see where I can answer him on that. I do not know where he's going with the article. I know.
No, Captain, I think it's fair enough, and as his lordship has said, take 5 minutes to read the article, and if you can confirm that that's the article that you had read previously, and what it said at the time, then it will save a lot of court time, I think.
Family, into ethusayo with this interrogation, when the lawyer was interrogating or cross-examining this witness, it's like he doesn't know his story. He doesn't know exactly what happened. Or they were just trying to squeeze some kind of information so that this lady CHOLOTA can implicate Ace Mahashule. We don't understand why they didn't inform her when they were going to the US. They took her by storm, surprise, knocking in her place without her knowledge that there was something like that was going to happen. Because at first, she was considered as a state witness. All of a sudden now, she has a case to answer because she failed to implicate Ace Mahashule. Because every time they will ask her questions, she will refer to the office of the premier, not the premier. But that was really confusing to them, that why is she not implicating Ace Mahashule? And those kind of things that the police sometimes do, or the investigators do, they're always looking for a certain answer because they are in a mission to arrest somebody. Even if the evidence is not there, they will push somebody to see if that person can easily implicate that person. For now, looking at this case, now this case is a trial within a trial. But it looks like the plane now is about to land. But all the wheels are off. It's what this lawyer has done to this witness, the captain. Because the lawyer was leaving no stone unturned. Because this lawyer is the lawyer for accused number 13, which is Ace Mahashule. And Mahashule used to tell us that he doesn't know about this case. He's got nothing to do with the asbestos money that was stolen. And no one has ever implicated him. And the only lady that they wanted her to implicate Ace Mahashule was CHOLOTA, who was at the university in the US. They made sure they strangle her. They stop all the funding and everything so that she can come back. There's a lot of interrogation that has gone through that lady. She needs a lot of counseling. And at the end of the day, as we see, this plane is about to land without wheels. Imagine a plane landing on the ground without wheels. Is this case? Is what this lawyer has done to this witness, because this witness has contradicted himself. At some point, he brought up that this lady has been saying, CHOLOTA has been saying, oh, everything was done in the office of the premier. But because they wanted a certain name, that certain name was Mahashule's name, but she couldn't bring that name up. But he himself, there is a point whereby there were documents that were sent to him, but he said they came from a certain office, but he never named any name, and he was questioned about that. Then he started stumbling as well with that. I don't know why, when police or investigators are trying to investigate something, when you give them the information, they keep pressing on something that they think, if you do this, that will help them. Because CHOLOTA, if she knew anything about this asbestos money and everything, she wouldn't have just hide anything. She would have just said, oh, Mahashule did this, and this. But because she cannot implicate somebody, knowing very well that that is a lie, I'm being pushed to implicate that person. Family, we are seeing this kind of cases. We even see in the case of Senzo Meyiwa, we're seeing the same problem of people who are behind bars, but we don't understand how they got in, because there's really people who were supposed to be behind bars are the people who were in the house when Senzo Meyiwa died. And the same thing in the office of Mahashule, the premier. There were so many people who were working there, who were working very close to Mahashule. But the only target that they wanted to target was CHOLOTA. And targeting CHOLOTA, they thought because she's a woman, they will squeeze her until she gives them the information they wanted. But only to find that there was nothing that they're getting from her. Now she has turned to be an accused, while she was a witness at the previous time. So I don't know what is this kind of investigation or this kind of case, because it seems like it has got no legs to stand. It is really stumbling. Same with the witness that was the captain. He was really struggling, contradicting himself with things that he misstep on them. Family, what do you think about this? Drop your comment. Don't forget to like, share, and subscribe. Where do you think this case is going? Do you think the wheels are still on the plane, or the wheels already, the plane is about to land without wheels? Drop your comment respectfully. Bravo, bravo, bravo.